Hello there, I'm Laura McHarrie at The Hidden Edge with another tea break tip on business models and tools to help you manage your growing business. Today, we're looking at the 5 fair reasons for dismissal and employment tribunals, essential information for employers to keep on the right side of the law. Dismissals are classed as automatically unfair if the reason for dismissal is connected with an employee's exercising specific rights in relation to pregnancy, family reasons, representing somebody else, trade union membership, part and fixed term employees, pay and working hours, including the working time regulations, annual leave and the national minimum wage. So what is a fair dismissal then? Is there such a thing? Well, let's have a look. There are 5 fair dismissal reasons: misconduct, capability, redundancy, legal restriction, and some other substantial reason. There used to be a 6th reason, retirement, but the default retirement age was abolished in 2011. Misconduct. Continuing misconduct will eventually result in dismissal on the grounds of misconduct. Very serious conduct issues such as theft, discriminatory behaviour are usually regarded as gross misconduct, and after an investigation, a gross misconduct finding can result in an employee summary dismissal, that is, without notice. Capability. Capability can include ill health if an employee, for example, has a long-term or persistent illness such as cancer that makes it difficult for them to do their job. But before you dismiss, as an employer, you'll need to consider how the employee can be supportive, give the employee some time to recover and to monitor the situation, have a full understanding of the employee's condition, treatment and likely prognosis, and have considered other options for them: change of role, part-time working, flexible working, for example. Poor performance, however, is when an employee is not capable of performing to a satisfactory standard within their role. In this case, prior to dismissal, the employer would usually be obliged to follow their performance management process, which is likely to include going through disciplinary warnings and giving the employee at every stage of the process time to improve, plus support and training if necessary. Redundancy. A redundancy is when an employer requires fewer or no workers. For example, if you're closing down, if there is less work for employees to complete, if you're moving, changing locations, if one particular role or function is no longer required, and if there is a reorganization of the work, meaning that there are fewer jobs or new jobs which are different to the old ones. Legal restrictions. This would be used when continuing to employ somebody would mean that you are breaking the law. So, for example, if you employ a lorry driver and they lose their driving license, and of course you have no other work for them, then the employee's right to work in the UK expires. You would still need to go through the formal dismissal procedure as in your terms and conditions of employment. And the last one, some other substantial reason. It's the catch-all. And to some extent it is true when, of course, the dismissals don't fit into any of the other 4 categories. There isn't a legal definition for this, but here are some examples of where it might be applied. If there is a significant conflict of interest in one of your senior employees whose partner works for a competitor, if there is a personality clash that causes substantial issues to the business, if there is an expiry of a fixed term contract, when an employee doesn't agree to changes in their terms and conditions, you could potentially dismiss them and re-engage them on new terms and conditions. You would need to go through the consultation process before you did this, though. Throughout any disciplinary or dismissal procedures, the ACAS guidelines advice suggests that you should raise and deal with issues promptly and should not unreasonably delay meetings, decisions, or confirmation of those decisions. You should act consistently. You should carry out any necessary investigations to establish the facts of the case. You should inform employees of the basis of the problem and give them the opportunity to put their case before any decisions are made. You should allow employees to be accompanied at any formal disciplinary or grievance meeting. And you should allow an employee to appeal against any formal decision made. On a scale of 1 to 5, with 5 being fab, rate yourself and your business on how well those guidelines are put into practice within your organisation. So there you go, in a nutshell, the 5 fair reasons for dismissal and what happens if you don't use those. Do download the templates from the Hidden Edge website, and whilst you're there, please share your stories of where this has worked or hasn't worked for you, because I'm building a portfolio of case studies and would love to include yours within that. So until next tea break time, enjoy the rest of this one.